Hi there, good afternoon everyone, and welcome to today's webinar on recent developments in relation to the enforcement of arbitral awards, in particular in the context of UK consumer protection. Great, well, thank you everyone for joining us today. Welcome to today's webinar on recent developments in relation to the enforcement of arbitral awards, in particular in the context of UK consumer protection. Our speakers today are myself, Jared Oyston, a partner in the dispute resolution practice here at Brodie's, and my colleague, Peter Begbie, an associate in the dispute resolution team also. If we can move on to the next slide, please. What we're going to cover today, the first thing we'll cover very quickly is what is international arbitration. We're conscious that not everyone attending today will necessarily know a huge amount about international arbitration. And so for those who may be less familiar with it, we will refresh memories on what international arbitration is and what some of its key benefits are. Speaking of its key benefits, we will then look at the enforcement of arbitral awards and why the enforceability of awards is such a big selling point in international arbitration. As part of that, we'll look at some of the grounds for challenging the enforcement of arbitral awards in the United Kingdom. And then I'll be handing over to my colleague Peter to look at 3 recent cases from the courts of England and Wales, which concern one of the available grounds for challenging the enforcement of arbitral awards in England and Wales, namely the public policy ground, and in this case, the protection of individuals' rights as consumers under the Consumer Rights Act 2015. So moving on to the next slide, first of all, what is international arbitration for those of you who may be less familiar with it? So arbitration is a form of alternative dispute resolution in which parties resolve their disputes through a private process before a neutral third party, rather than going through the more traditional national courts. So parties to a commercial arrangement can agree, usually at the outset of their relationship, by including in their contract what's known as an arbitration clause. They'll agree that rather than leaving their disputes to be resolved by national courts, they'll instead essentially convene a private process for that purpose. And when we refer to international arbitration, we're referring to arbitration between parties domiciled in different legal jurisdictions. So arbitration is conducted before a tribunal, usually comprising 1, 3, or 5 arbitrators. And an arbitral tribunal can be convened on an ad hoc basis or under one of a number of national and international arbitral bodies, such as the International Chamber of Commerce based in Paris, the London Court of International Arbitration, or the Scottish Arbitration Centre headquartered here in Edinburgh. All of those bodies, of which there are several around the world, essentially facilitate and promote arbitration, and many have their own institutional rules for the management of arbitration processes. The arbitration will then effectively operate in a way akin to a traditional court, in the sense that there will be a tribunal composed of expert decision makers, often judges or lawyers, but potentially experts in other fields if the dispute calls for it. And it will have a process for the presentation of evidence and arguments to those decision makers. And just as in a court, once they've seen the evidence and the arguments, those decision makers will then deliberate and issue a decision, which is known as an award, and which is akin to a judgment in a more traditional court process. So in terms of the quality of the decision-making process, it's every bit as robust as a traditional court, but with several really significant advantages which are attractive to a lot of parties. We could spend an entire webinar discussing those advantages, but in very high-level summary, they include things like finality. So with an arbitral award, there tends to be much less scope for appeal than there is with a judgment from a national court. Confidentiality, the default position in arbitration is that unlike the traditional open justice public court process, arbitration is private and confidential. Arbitration is very flexible because it is a creature of agreement between the parties. It's fair to say that there is often greater flexibility for the parties to tailor the process to their needs and their particular dispute than there often is in traditional courts, which are often constrained by sort of more procedural rules and conventions. But it's fair to say that none of those advantages would be worth very much at all if it weren't for what is perhaps the key benefit of international arbitration, which is enforceability. It's all very well having a robust, definitive, confidential, flexible dispute resolution process, but no one is going to use it unless they know that they will be able to enforce the award that they obtain at the end of it. So moving on to the next slide, this brings us on to what is really the focus of this webinar, which is the enforcement of arbitral awards. So what do we mean by enforcement of an arbitral award? We're referring here to the position where a party to an arbitration has obtained an award in its favour from its arbitral tribunal. So it's been through the process and it's come out the other side as the successful party. And it now wishes to obtain the fruits of that arbitral award against the unsuccessful party. Those fruits will usually be a sum of money that the tribunal has decided is payable to that party, although non-monetary awards are also possible. But in either case, the successful party will want to ensure that the unsuccessful party complies with the award, usually by paying the sum of money that's been awarded. And to the extent that the unsuccessful party does not comply voluntarily, the route available to the successful party is to take its award to the courts of a particular jurisdiction and ask those courts to enforce the award, essentially asking the courts to order the unsuccessful party to comply with the award. That jurisdiction would typically be the jurisdiction of domicile of the unsuccessful party or another jurisdiction where that party may have assets. So the enforceability of arbitral awards is really central to the process of international arbitration. Without a robust and predictable process for enforcing arbitral awards, arbitration would be a far less attractive method of dispute resolution. The greater the doubt as to the enforceability of arbitral awards, the less willing parties will be to invest time and money in an arbitral process or to agree to arbitrate in the first place. But obviously, once a party has gone through that process and been successful, enforcement is the means by which it is able to convert its arbitral award into payment. So next slide, please. And so a great deal of time and thought has been invested by the arbitration community, by governments and by court systems to ensuring that arbitral awards are indeed enforceable. And that effort has been remarkably successful. Arbitral awards are, generally speaking, easier to enforce internationally than court judgments. Even here in the UK, where we have very ancient and highly respected court systems of England and Wales and Scotland, the reality is that an arbitral award is more readily enforceable worldwide than a judgment from the courts of England and Wales or Scotland. And that is in large part thanks to the 1958 New York Convention. Next slide, please. So what is the 1958 New York Convention? This is a really international custom-made enforcement regime. Essentially, under the convention, contracting states are obliged to recognize arbitral awards issued in other contracting states and to enforce them in accordance with their national procedural rules. And those principles are subject to only a handful of very narrow exceptions. And crucially, 172 states worldwide and counting are party to the convention. We mentioned on the slide there are a couple of recent new signatories. There are now only 23 states in the whole world that are not party to the convention. And with the greatest respect to those states, it's fair to say that for one reason or another, they tend not to be major international business destinations. So the convention is a highly successful, well-recognized and stable system for the recognition and enforcement of arbitral awards, more or less worldwide. So next slide, please. So moving on to the domestic framework in England and Wales, how does that international framework translate into enforcement here in the UK? The enforcement of arbitral awards in England and Wales is governed primarily by the Arbitration Act 1996, which applies in England and Wales. I should say as well that since 2010, we've also had the Arbitration Scotland Act. In this webinar, we are focusing on the enforcement regime in England and Wales simply because that's where these interesting new cases that we're going to be looking at have arisen. But the Scottish Arbitration Act provides for a very similar enforcement regime in Scotland, the same basic principles, the same exceptions effectively. And so there's no reason why cases engaging very similar issues couldn't arise before the Scottish courts, and it'll be very interesting to see if that happens. In terms of the Arbitration Act in England and Wales, Section 101 provides for recognition and enforcement of New York Convention awards, and provides that any such award, with the permission of the court, may be enforced in the same manner as a judgment or order of that court. And in addition to those sections relating to New York Convention awards, Section 66 provides a more general provision, allowing, with the court's permission, the enforcement of an arbitral award regardless of where it's issued. So what the Arbitration Act does is effectively provide that where a party presents to the court an arbitral award which on its face is valid, the court will enforce it against the respondent effectively as if it were a judgment of that court, and unless the respondent is able to rely on one of the recognized defenses or grounds of challenge to enforcement. So what are those grounds of challenge? The Arbitration Act does set out a number of limited grounds for challenging enforcement of an arbitration award. There are two principal grounds that are most often referred to. The first is a mandatory ground. So under Section 66 of the Arbitration Act, the court must decline to enforce an award where the defendant can show that the tribunal lacked substantive jurisdiction, which makes obvious sense if the court can be convinced that actually the award in question has come from a tribunal which really never had any jurisdiction to issue such an award. It obviously makes sense that the court will not and cannot enforce it. The second is a discretionary ground. Under Section 68, this provides that the court may decline to enforce an award where the defendant can show that there's been a serious irregularity affecting the tribunal, the proceedings, or the award. So those are two that come up most often in this kind of situation. However, there is another provision of the Act which leaves open a route to challenge enforcement of an arbitral award. Section 81 of the Act expressly provides that nothing in the Act excludes the common law rule as to the refusal of recognition or enforcement of an arbitral award on the grounds of public policy, so that the Act effectively leaves untouched common law rules which allow the court to decline to enforce an arbitral award because that arbitral award conflicts with public policy. There are also similar provisions governing New York Convention awards. So Section 103 of the Arbitration Act also sets out a number of defenses to enforcement of New York Convention awards. But broadly speaking, those are more tightly defined versions of the more general grounds we just looked at, being lack of jurisdiction and serious procedural irregularity. And Section 103 also makes clear that the court may decline to recognise or enforce an award if it would be contrary to public policy to recognise or enforce it. So in summary, in terms of this introduction, enforceability is a key benefit of international arbitration, and indeed, in many ways, the viability of international arbitration as a method of alternative dispute resolution does depend in large part upon a robust and predictable enforceability regime. And one of the very limited grounds for challenging the enforcement of arbitral awards here in the UK is where the award may be contrary to public policy. And so when cases come along which perhaps alter or provide additional guidance on how that exception applies, those are inevitably of great interest. And so I'm now going to hand over to my colleague, Peter, who is going to speak about a number of recent cases in which the courts of England and Wales have been asked to apply the public policy defence and decline to enforce an arbitral award on the basis that enforcement will be contrary to the rights of individuals under the Consumer Protection Act 2015. Over to you, Peter.
Thanks, Jared, and good afternoon, everyone. We can flick on to the first slide, please. We've been hearing all about arbitration and, in particular, enforceability. And arbitration is often especially attractive as an option because of those narrow, limited grounds which Jared has just described: jurisdiction, procedural regularity, and, of course, public policy. So I'm going to have a look at three recent cases, all in relation to arbitration in consumer contracts, in which the public policy challenge is featured one way or another. We'll look at some of the key principles of consumer law that were engaged, and I'll then try and draw out the key points from the court's reasoning, with a view, I hope, to identifying some practical points for drafting effective arbitration clauses in the business to consumer context. Next slide, please. So first, a quick look at the context in which this recent flurry of cases has arisen. Two of the cases arise in the context of digital assets, a crypto exchange, which I'm sure will be familiar to most by now, and also in relation to a non-fungible token. And I have to say, I'm very much hoping that I'm not asked to explain what one of those is, but let's just say that it's a digital asset, just like cryptocurrency is. And it's fair to say that arbitration appears to have become the forum of choice for many crypto and digital exchanges for all of the reasons that Jared has explained. Of course, that's logical for a business with customers in all corners of the globe to prefer arbitration because of the perceived ease with which they can enforce New York Convention awards. And crypto exchanges are far from alone in preferring arbitration. A 2019 study found that 81 of the Fortune 100 companies, so the largest companies in the US, use mandatory arbitration, and a slightly earlier study found that 48% of 200 websites which were surveyed, mainstream websites offering goods and services to consumers, included binding arbitration in their terms and conditions. So we can see that a key driver of these recent developments then is the context of the global online marketplace. I've mentioned there on the slide the balancing act that the law attempts to strike between pro-enforcement of arbitration awards, and English courts traditionally have been very pro-arbitration and indeed still are very pro-arbitration and pro-enforcement. Balance that with the other side of the scales of justice, which in this case is consumer protection. The fact is, and the court recognised this in the case of Soleimani, which we're going to come on to, is that some of the benefits of arbitration that Jared has described, privacy, confidentiality, finality, choice of forum and governing law, can, in the consumer context, operate unfairly. And indeed, for that reason, arbitration clauses are expressly identified in the consumer legislation as being clauses which may be regarded as unfair. The relevant framework here is Schedule 2 to the Consumer Rights Act. I'll be talking about the CRA a fair bit, but it sets out in its schedule sample consumer contract terms that may be regarded as unfair, known colourfully as the grey list, which includes arbitration. The grey list was extended to include arbitration clauses under sections 89 to 91 of the Arbitration Act. So, for example, consumer claims under £5,000 are automatically unfair. If they have an arbitration clause, it's automatically unfair. Whereas for consumer claims above £5,000, assuming that the other requirements I'm going to come on to are met, the clause is still subject to the fairness provisions of the CRA, irrespective, for example, if it's got a foreign law clause in there. The last bullet I've mentioned there is just simply that businesses need to consider that under the New York Convention, the public policy ground may offer consumers in other jurisdictions, not just the UK, but very much also those subject to EU law, which is the genesis of UK consumer law, a potential escape route to the extent that consumer protection forms part of public policy in those jurisdictions. Next slide, please. Okay, so a quick whistle-stop tour of the relevant principles of consumer law that are engaged here. A consumer can invoke their rights in two ways when faced with an arbitration agreement, including a foreign governing clause in a contract. They can be proactive and launch claims in the courts to vindicate their rights effectively, seeking declarations, for example, under the CRA, that certain terms might be unfair. And in that case, the consumer might have to deal with defending a stay application. That was the case in Soleimani, as we're going to see. Alternatively, they can wait to see what happens. They can wait to see what the business does, commence arbitral proceedings, issue an award, and then challenge it at the back end. And that's what happened in Zhang and also in Payward, as we're going to see. So those are the two different approaches. However, it doesn't really matter which approach the consumer opts to take. The three questions are always largely the same. Number one, is the individual a consumer? Number two, is the contract in question subject to a foreign governing law clause? And if it is there a close connection between the contract and the UK? And the third limb is whether the relevant contract term is unfair within the meaning of the CRA. Next slide, please. So step one, is the individual a consumer? And section 2, subsection 3 of the CRA defines a consumer, as you can see on the screen, as an individual acting for purposes that are wholly or mainly outside that individual's trade, business, craft, or profession. That's a fairly broad definition, as you can see, and it's certainly been widely construed by the courts. The CRA was enacted in the UK in order to give effect to EU law on unfair terms in consumer contracts, and so there's a whole body of European case law that's relevant, notwithstanding Brexit, because the principles are now embedded in English law. And then there's relevant domestic cases, of course. So, for example, that collective body of law has well established that being wealthy does not prevent an individual from being a consumer. And in the Zhang case, which I'm going to talk about some more, the amounts at stake under the personal guarantee were some £60 million. That had no bearing on the analysis of whether Mrs. Zhang was a consumer. I just want to touch very briefly on the concept of functional connection. This was a test formulated by the European Court of Justice as a slight expansion of the test that became part of CRA that's on the screen. And it considers whether the person acted for purposes relating to his trade, business, or profession, or because of functional links that the individual has with that company. For example, a directorship or a non-negligible shareholding. In that case, it was two individuals who had given a personal guarantee in support of their son's business, and the court found that they had no connection with the activities of their son's company, and therefore that they met the test of being a consumer because of the lack of a functional link. In Zhang, as we're going to see, the judge rejected suggestions that Mrs. Zhang had a business interest in the company, which was sufficient to negate her status as a consumer, notwithstanding the fact that Mrs. Zhang had become extremely wealthy from her husband's business dealings in the company, and also notwithstanding the fact that she had her own shareholding, albeit that shareholding was slightly less than 0.5%, but the court confirmed that that was not sufficient to give rise to a functional link. Next slide, please. So step 2 is to assess whether there is a close connection, and you'd be forgiven for thinking that an agreement subjecting the parties to a foreign governing law clause should prevent the English courts from getting involved. But of course, Section 74 was specifically designed to prevent consumer-facing businesses from evading UK consumer protection law by using foreign governing law clauses, and that was achieved through the concept of close connection and secondary concept, which is an EU law concept of directing activities in the UK. So under Section 74, subsection 1 of CRA, the key provisions of the CRA will apply to contracts notwithstanding an agreement to subject them to some other governing law, so long as the contract has a close connection with the UK. This is a fact-sensitive question, and the courts will consider a very wide range of factors, including connections with other countries. The fact that the consumer is resident in the UK will not necessarily constitute a close connection, and indeed in Zhang, the judge held there that Mrs. Zhang, who had been resident in the UK since 2013, she was also resident in the UK at the time that the personal guarantees were granted, but the court held that the connections with Hong Kong there were so great as to be overwhelming. I should say that that case is currently under appeal, and the appeal was heard just last week. So I have no doubt that that point will be challenged by Mrs. Zhang's counsel in the court, but as it stands, the position is that being resident in the UK will not necessarily constitute a close connection. In Payward, which is one of the other cases I'm going to look at, despite the user agreement being governed by Californian law, the judge concluded that it did have a close connection to the UK because the crypto exchange operated via a UK company. The services were paid for in pound sterling and payments made to and from English bank accounts. Interesting point actually is that it's the same judge in both of those cases, but he came to the opposite conclusion in each case. Found that Mrs. Zhang did not have a sufficiently close connection with the UK, but he found in Payward that the contract there did. Just a quick word on directing activities. In Soleimani, which is the third case that I'm going to talk about, the High Court found there that the defendant's activities were directed at the UK based on its various marketing efforts and in-person promotional events here. So we can see that there's a few routes to tying a contract to the UK, and we can see with these cases actually that the court's prepared to interpret that fairly widely. Next slide, please. So thirdly and finally, on these principles of consumer law was the term unfair. It's under section 62 of the CRA, there's a general requirement of fairness for consumer contracts. If there are core terms, then these fall to be assessed for fairness only if the term itself was not transparent and prominent. I've not got time to go into the principles of transparency and prominence, but they're dealt with, particularly in the case of Zhang. I mean, we'll touch on them in a few moments. Non-core terms, on the other hand, are assessed for fairness at the outset. And this is the classic example of businesses trying to hide key or particularly oppressive terms in the small print. I mentioned briefly earlier the grey list under Schedule 2 of the CRA. It contains a non-exhaustive list of terms of consumer contracts that may be regarded as unfair. So, for example, in Zhang, Mrs. Zhang challenged both core and non-core terms of the personal guarantee. It was in a subscription agreement. And in respect of the core term, which the court said the guarantee was, Mrs. Zhang didn't get past the first hurdle because the judge found the term was transparent and prominent, notwithstanding the fact that Mrs. Zhang herself had not read it. Whereas in Hayward, the judge considered that the Californian governing law clause was unfair because it precluded the claimant from bringing substantive claims under FSMA against the exchange. So, and just finally, in Zhang, in contrast to that, Hong Kong law was fine, in part because Hong Kong judges are much more experienced in applying UK law. So I think what comes out of those principles certainly is that it's very fact sensitive indeed, even down to the particular individual. Next slide, please. So I've mentioned the three cases some bit, but we'll just go into a little bit more detail to understand each of them. First up is Mrs. Zhang and Eternity Sky. So as I've said, she was a resident in Hong Kong until 2013. She then moved to London, and she granted in 2016 a guarantee in favour of Eternity Sky Investments in respect of bonds issued by her husband's Hong Kong-based company. The guarantee was governed by Hong Kong law, and it had a clause saying that disputes would be settled by arbitration in Hong Kong. Mrs. Zhang regrettably once more did not read the guarantee before signing it and did not take legal advice. So when the company failed to redeem the bonds, Eternity Sky obviously demanded payment and obtained an arbitral award in its favour, confirming that Mrs. Zhang was liable for some £64 million. She applied to set aside an order for enforcement made in the English, given in the English courts. And she argued, of course, that it would be contrary to English public policy because the arbitration clause contained terms which were unfair pursuant to the CRA. Well, the court held that although she had entered into the guarantee as a consumer, she'd acted for purposes of a private nature, being her marriage, and that the CRA did not apply. Because, as I mentioned earlier, the court felt that the personal guarantee's connections to Hong Kong were so great as to be overwhelming. And this was despite, as I say, Mrs. Zhang being resident in the UK since 2013. But the court said that even if the CR did apply, then even then the personal guarantee would not have been unfair because clause 2, that was a guarantee, remember, was transparent, prominent, and not unfair. The choice of Hong Kong law had not been unfair because it was held, as I mentioned before, that arbitrators in Hong Kong are well accustomed at applying English law. And what the court said is that the choice of Hong Kong law would only have been unfair under section 62 if it gave rise to a significant imbalance, and that the only difference the choice of law had made was that the guarantor, Mrs. Zhang, had had to engage Hong Kong lawyers. That hadn't been unfair to her, the court said, because of her established connections to Hong Kong. Nor was the arbitration provision unfair. Fairness could be assessed, the court said, by considering whether a term was one that properly informed consumer might reasonably be expected to agree to. And the court said that it was not obvious that Mrs. Sang would have been expected to object to Hong Kong arbitration. As I mentioned, this case was heard on appeal by the Court of Appeal just last week, so watch this space. Next slide, please. Okay, I'm conscious of time, so I'll canter through the facts of these next two cases fairly quickly. Mr. C, as I'm going to call him, undertook various trading activities on a cryptocurrency trading exchange called Kraken, and lost more than £600,000. Now, before Mr. C had traded on the exchange when he was signing up, he'd accepted terms and conditions containing an arbitration clause. I should mention that those terms and conditions appeared as a click wrap. So for those of you who are unfamiliar with that term, click wrap is the type of terms and conditions where you're required to scroll through them and confirm affirmatively that you've read them. That's in contrast to browse wrap agreements, which are generally displayed as a link to the terms and conditions on the website. So the gold standard, I suppose, is click wrap. And here, as I say, contained in those terms and conditions was an arbitration clause referring disputes to JAMS. JAMS is one of the arbitral institutions in the US. A JAMS arbitration seated in California. Mr. C's contract was, however, with, there was a third claimant, it's not listed on the screen there, but it was an English company, and the contract incorporated those terms of service, which I was just mentioning, including the arbitration clause. So Mr. C challenged the validity of the arbitration clause, again on public policy grounds, and the judge noted that he considered click wrap agreement sufficient to bring the clause to Mr. C's attention. However, concluded that in the particular circumstances of the case, enforcement of the arbitration award would be contrary to public policy. What the judge said was that requiring Mr. C to participate in a California-seated JAMS arbitration was unfair for two reasons. First of all, the practical disadvantage and expense of having to hire foreign legal counsel in California. And secondly, that the arbitrator would have no experience of or even requirement to apply English law, including UK consumer legislation and relevant principles of the Financial Services and Markets Act 2000. But an interesting point about this case in particular is in relation to the first limb of the consumer test, which is Mr. C a consumer? And the judge accepted that it was possible for Mr. C to open a trading account with the intention of generating an additional income stream without doing so in the course of a trade, business, craft, or profession. And this was despite Mr. C ticking the pro box when he signed up. So if I remember correctly, there was 4, I think, sort of tiers of membership, starting from entry level up to what was described as pro, standing for professional, of course. However, Mr. C was a lawyer, and he gave evidence that this was his full-time job and source of income when he opened his account. And the judge agreed that Mr. C was knowledgeable, experienced, and even sophisticated in trading, but crucially, he found that all of that experience post-dated the opening of his account, which rather begs the question why Mr. C described himself as suitable for the pro level. Next slide, please. So the third and last case I want to just touch on very quickly is Mr. Soleimani. Now, this was the individual who took part in an online auction and placed a successful bid of $650,000 for a non-fungible token. Apparently, this was associated with a digital artwork. Seems rather a lot of money. But ultimately, Mr. S claimed that the auction was unfair. He perhaps had buyer's remorse. He refused to pay, in response to which Nifty Gateway commenced an arbitration, again under the JAMS rules in New York, because that was provided for in its terms and conditions. In the meantime, Mr. Soleimani initiated legal proceedings in England to contest the validity of both the arbitration agreement and the auction itself. Now, the two grounds of dispute are fairly complicated and technical. The first was in relation to jurisdiction, which was rejected, so thankfully we don't need to bother with that one. The The second was whether a stay ought to be granted. And the court refused to grant a stay. And in doing so, the Court of Appeal held that it was properly arguable that there was a consumer contract with a close connection with the UK. And this is a key point, that the English courts would therefore be better placed to determine whether the arbitration agreement was null and void, inoperative, or incapable of being performed, and it ordered a trial on those issues. I'm just going to very quickly show you the clause in question. So if we could skip to the next slide, please. So really, this is just to show I mean, in some ways, that this clause looks like it's left no stone left unturned. You can see that it uses extensive block capitals, which relate to the questions of prominence and transparency. If we click on to the next slide, please. This next one shows the arbitration clause itself. And again, one might think from looking at the length of that, and indeed looking at the language, that it looks fairly foolproof, maybe even watertight. You know, it says, please read the following agreement to arbitrate in its entirety. This clause requires you to arbitrate disputes with Nifty Gateway and limits the manner in which you can seek relief from us. So, you know, there's no question about fair notice there. I think what really was the issue here for Nifty was that the agreement was not bespoke to someone that's resident in the UK. And that takes me on to my final slide, which is a quick look at some of the lessons that we can take from these recent cases. So I think firstly and most importantly, the judgment in Zhang has confirmed that arbitration awards can indeed be enforced in England against consumers. And what the court said was that the mere fact that a consumer contract provides for disputes to be resolved in arbitration does not make it unfair. And that's probably also implicit from the Consumer Rights Act anyway, in relation to claims with a value of greater than £5,000. They're potentially unfair, but they're not unfair as such. Second point, takeaway, is that an arbitration clause may be deemed unfair if it's not clearly signposted to the consumer. So we would recommend that companies review their websites and contractual frameworks to ensure that online terms, including arbitration clauses, are sufficiently brought to the attention of users. For example, they may wish to provide that the arbitral seat and governing law reflect the consumer's country of residence, depending, of course, on the potential jurisdictions involved. And perhaps even consider tailoring the arbitration process and the level of arbitrator administrative fees to the value of the claim. And finally, just to carry out a risk assessment against their customer base. What is the profile of that customer base, and does it fit the definition of consumer? Does the business direct itself at the UK or the EU, for example, through online or marketing events, promotions, that kind of thing? Perhaps even customer service telephone numbers based in the UK, or ability to pay in pounds sterling on their website. All of those circumstances are relevant to the factual assessment which the court is tasked with carrying out. And finally, they should consider what dispute resolution procedures best suit their business, because arbitration may not always be suitable, but I think it's clear from these cases that there's still a role for a carefully drafted arbitration clause in consumer contracts in the context of the global marketplace, particularly with all of the benefits that arbitration can bring. And that's all that I was going to say. Thank you.
Great.
And we're happy to take questions.
Great. Thank you very much, Pete. As Pete says, we're very happy to take any questions that anyone may have. We have had one come in on the Q&A so far. Pete, I'm conscious that you may not have had time to look at it or give it any thoughts, so I'm happy to sort of give it my thoughts initially. The question is, do these cases suggest a shift towards consumer protection when faced with attempts to enforce foreign arbitration decisions? Pete, obviously I'd be grateful for your thoughts on this once you've had the opportunity to digest the question, but I think I would suggest that it perhaps doesn't, or it's far too early to suggest to say that it does. I think it's easy to look at this and think that what we've got here is sort of a battle between arbitration and public policy and protecting consumers, it's important to keep in mind, I think, that actually what we've really got, and Pete hit the nail on the head there on his last slide, is that we're actually balancing two competing or potentially competing public policy interests. There is a huge public policy interest in upholding arbitration as a way of resolving international disputes. That's reflected in the sort of international architecture that the UK signed up to, and the England and Wales Arbitration Act and the Scotland Arbitration Act. There's this huge public commitment on the part of government to arbitration, and that obviously is all about public policy imperatives like access to justice, choice, protecting court resources, making sure that people who don't actually want to use the court have an alternative to go to, so that those who do want to use the court have access to it. So there's huge public policy impetus behind protecting arbitration, and I think what we're really seeing here is the same balancing of those two partially potentially competing public policy interests just being played out in slightly new territory with things like crypto, slightly different types of consumer from what we might ordinarily consider to be a consumer. So I think it's probably too early to say that there's any sort of shift here. It's really just the same balancing act being sort of employed in slightly novel circumstances. Pete, I don't know if you have anything to add on that.
Yeah, well, I very much agree with that. I don't think it does necessarily indicate a trend. I think that the courts have actually been very careful to make clear that just because an arbitration agreement features in the consumer contract, that won't necessarily make it unfair or unenforceable. The point actually is it's fact specific, and when one looks at the facts of the three cases that I've described, they're all very, let's say, non-standard consumers and quite unusual sets of facts for those individuals. But ultimately, I think what the courts recognise is that in the global marketplace, which I think it's fair to say is certainly on its way to, if it's not already becoming the dominant marketplace around the globe, the courts recognise actually that those businesses and indeed the customers need effective fora for resolving their disputes. And arbitration, as we've heard, is an extremely attractive and useful option because of its ability to operate across borders. And so, no, I think it remains to be seen. But so far as it stands, the two continue to coexist, albeit subject to the conditions that we've discussed today.
Great, thanks, Pete. I can't see any other questions. This is a last chance for anyone to put up their hand if they've got any questions coming out of today's webinar. Alternatively, if anything comes to anyone after this that they want to ask us, then please do feel free to get in touch with us using the contact details that have just very helpfully come up on the screen there. But thank you very much to everyone who's come along today, and we'll no doubt see you in another forum soon.